Item number 1.
1 minute. Where is Mr. Banerjee? Mr. Banerjee, how much time you are likely to take?
It will take about an hour, so it's not complete today. I may have to go on.
No. Today you complete, please.
I don't mind. You only give me that time. I need an hour. So that's the problem. It's already 1 o'clock.
So you be prepared in about 15-20 minutes to start.
Yes.
Okay.
I'm ready now.
Yes.
My lords,
That number 1 is not yours. It is 1. No, my lord.
Your Honor, I'm filing an application for impleadment. I've filed an application for impleadment in PIL 9 of 2024, my lords. We are the Seng Samla Laitamkra, my lords, and we are here to bolster the case of the petitioner by way of a dossier where we have brought on record
Can I have the petition?
the various stakeholders of the area who have expressed their concerns caused by the unregulated hawking in the area, my lords. We have obtained the signatures of the Rangba Shnong, the Rangba Dong, the members of the Senkinthai, the principals, students, parents of students, business owners of the area, my lords, highlighting the fact that that Laimakra is actually being clogged by the president.
Where is your application? Which is the application number? This one?
Yes.
What are your prayers?
My lords, impleadment, my lords, in PIL 9 of 2024, and my lords, also that the dossier, my lords, which I have annexed as Annexure 3, may be allowed to be used by parties in the course of the hearing.
What is dossier? Annexure 3? Page?
My lords,
But, this is
page 11, my lords.
Lords,
No, not to me.
We are here only to bolster the case of the petitioner, my lords.
This is different from police service.
Samla, my lords, is a local body defined under Section 2, Clause X of the KHEDC Administration of Ilaka Act.
my lord, in fact, the subject matter which the present applicant she wants to bring through these applications, my lord, this has already been.
Speak louder, it is.
My lord, in fact, the subject matter which the applicant wants to bring, my lord, this has already been seized by the PIL, wherein, my lord, the questions of, wherein, my lord, the problem or issues faced due to the hawking in the roadside, my lord, that is already been looked after by this court, my lord, even for other areas which my lord has already directed on the last occasions, even for the Limekra.
Where have you directed? Show us. I think the drive took place in Police Bazaar.
Police Bazaar has already been complete, my
The
lord.
drive is already over, your lordship,
Already
as far as
relocated.
Petailat is concerned. Now we would like to shift to Laimukra, your lordship.
My lords, we represent the Seng Samla Laitamkra area, my lords.
But the Hawkers Association, etc., are representing the entire hawkers in the city, your
My
lordship.
lords, the Seng
So now
Samla-
if we allow Seng Samla Laimukra to be a part in this thing, then there'll be many other Seng Samlas from different localities who would also like to come and be impleaded, your lordship. So that would make the whole thing more confused, your lordship.
My lords,
May I, my lord, I represent the Meghalaya Hawkers Associations, my lord. This, particularly speaking about the implement applications, my lord. My lord, this is a public interest litigation. My lord are very much aware of the problems of the traffic and so also the unregulated hawking, my lord. That's the reason why my lords have been passing orders my lord have already appointed a special officer to look entire, my lord, the manner in which COVs are to be and how they are going to be issued with and how they are going to be hawkings, my lord. So therefore, my lord, impleading any Seng Samla, my lord, a youth group, my lord, which is, if translated into English, my lord, rather they're just bringing on records what is already aware by my lords. They're bringing the problems faced by my lord. That is very much aware. That is a reason why we are trying, all of us, we are trying to regulate, my lord. So therefore, bringing more and more parties to this is only going to confuse and complicate the matter, my lord. Therefore, my lord, I on behalf of the hawkers associations, my lord, we strongly object to these impleadment applications, my lord.
My lords, Latmakra, my lords,
Is a part of Shillong or not?
yes, my
Yes,
lords.
it is a part
My
of
lords, here the special mention is required on behalf of the Seng Samla, my lords, which is a youth body, because, my lords, this area is the educational hub of the state, my lords. It houses around 25 schools and colleges. Every institution has around 2,600 students, making the footfall of students alone around 80,000, 5 days a week, my lords. I have to be heard, my lords, because I am directly affected by whatever outcome of this particular suit, my lords.
You are a society.
I am a society. I'm a registered society, my lords.
What is the object of the society? What is the...
My lords, kindly, I have just passed on the Act, the KJDC Ilaka Administration Act 2023, my lords. Here, my lords, kindly turn to Section 2, Clause X. The Seng Samla, if I'm permitted to read, my lords.
Public education, their questions, what is the... Yes. Because the government people on the phone now, because in case they do any wrongdoing, we can confirm the people. Yes, please take down. Is it suo motu or is there a petitioner?
There's a petition.
This is a petition, my lord.
Which has been registered also. Your Lordship.
TL
My
9
lords.
PIL3.
on Hawkers, my lord. TL 9 of 2024, my lord.
You're the amicus.
No, my lord. I'm the petitioner in that case, my lord.
Mr. Yubin is the amicus.
No, my lord. I represent the,
The
respondents, the hawkers, my lord.
Hawkers.
PIL 17, I am the petitioner also.
That is on traffic.
On
That is on
issues
traffic,
also.
Your Lordship, not hawk.
And due to
And
lot-
PIL 9, who's the petitioner?
I'm the petitioner, my lord. Here. That is on hawking, my lord.
And PIL 17 and 9 are clubbed together, Your Lordship.
You wish to be added in 9 and 17.
9 only, my lords.
This is an application by Seng Samla Lightum Kra within quotation Leng Skem Ha Ka Hok quotation closed. Annexure C. To be added in the public interest litigation, bracket PIL 9 of 2024. In this application, it is stated that this society which section of the act you were
Section 2, clause X.
is a quotation Seng Samla unquote within the meaning of section two within bracket X of the Khasi Hills Autonomous District bracket administration of Elaka bracket closed amendment again within bracket Act 2003 and is a registered society under the Societies Registration Act. It expresses grave concern over unlawful or unauthorized activities by hawkers in the Laitum Kra area of Shillong. Paragraph. It wants the reach of the orders passed by this court in clearing some areas of the city of unauthorized hawkers to extend to Laitum Kra. By evicting these illegal vendors from the street and making the from the road and making it cleaner, and convenient and safe for use of for pedestrians and vehicular traffic. Paragraph. The impleadment of the applicant is opposed by the petitioners, comma, Hawkers Association and learned advocate for the state, on the ground that the court has in this public interest litigation already taken cognizance of this malady in the thoroughfares of Shillong, full stop. Its orders covers the entire city, full stop. According to Mrs. Yangi Learned, Additional Advocate General, the work that has been done in the Police Bazaar area would be carried forward to other areas also, stage by stage. Full stop. There is no necessity of further entities being involved in the public interest litigation, as that would, as that might complicate matters. We have also considered the submission of learned counsel for the applicant that the society represents the youth of the area, Raitum Kra. Full stop. The members of the society are active citizens of the state and are deeply interested in the upkeep of the street in the roads and streets, footpaths in the said area. Paragraph. Who's representing the Shillong
Municipal Board?
Yes.
I am representing my lord.
Yes. We direct the Shillong Municipal Board to file a report in this court.
My lord, as per the last order, we have submitted an affidavit, we have filed an affidavit on para 12 and 13 in connection with the report submitted by the special officer. We have,
No, that is only that area.
my lord,
This area, lighter mode.
my lord, we will do that.
With regard to the number of vending licenses issued for the purpose of street vending. Full stop. The council is also directed to make an inspection and mention in the report the names and number of the vendors who are vending merchandise without a license. Such report should be filed in this court by when is this matter due again? Hawker's matter? Or disposed of?
No, my lord. Today it was fixed, my lord. It's not disposed of, my lord, as yet.
The main matter is fixed today.
Yes.
It is fixed to the
All right.
lordship for affidavit by the
By 28th, list the main public interest litigation along with this application on 29th. For the time being, the applicant Seng Samla, Latimuk Leng Sem Swanso are allowed to participate in the proceedings by their presence only,
Great.
without being added as a party. Full stop. The question of the societies being added as a party will be considered on the adjourned date.
Right.
A copy of the report be circulated to all appearing parties.
We have circulated.
My lord, before
We'll
my
circulate.
passed away with reports, my lord, may I be permitted to place on record a written submission on behalf of the Hawkers Association in reply to the affidavit filed by the municipal, my lord, CEO, my lord.
Yes.
Just on report, my lord. We'll argue on the next date, my lord.
This is a report or affidavit?
This is an affidavit, ma'am.
As an affidavit, I'm sorry, my lord. Just a written submission is not in form of, just to assist, my lord. I will press on the next
Is
date.
affidavit or written submissions?
It's a written submission, my lord, not affidavit, my lord. May I be permitted, my lord, just to place so that this will be a great assistance to my lord on the next day.
All right. At the end, you write written submissions on behalf of the Hawkers Association,
My lord,
submitted by Mr. Yobin, learned advocate, is taken on record.
my lord, I'm grateful, my lord.
copy will be given to us.
Number 2.
All right.
Lord, I have filed a short report, my lord. The next meeting of the committee, my lord, that is scheduled on 27th August 2025. So, if this,
It has not taken place up to now.
my lord, one meeting has already been held, my lord. A committee was constituted, and the next meeting is scheduled on 27th August, my lord. So, if the matter can be listed after this date, my lord, so that we can file a detailed report.
All right. Learned amicus curiae files a report
I've just received the report just now.
to the effect that the next meeting of the committee is convened on 27th August. There is nothing else in the report.
No, my lord.
Let such report be circulated to the appearing parties. List this public interest litigation on 2nd September to ascertain the outcome of the meeting of the committee.
Obliged.
Number 3.
Wait, please, my lords.
Yes.
Plus, this is the tree felling matter. Me and the learned advocate general, my lords, we've caused an inspection of the area yesterday.
Yes.
My lords,
We hope you were provided good facilities and amenities for the visit.
my lords, this part, the inspection we conducted was in Shillong, my lords, where the forestation
ropeway,
has.
my lord, where the ropeway is going to be
The
installed.
other one, my lords, we've not been able to go due to paucity of time. We will go and report back to your lordships, my lords.
Then we will keep it 2 weeks later.
My lords. Even here, my lords, what we've noticed is, and the officers were also present yesterday, my lords, some amount of replanting can be done in this area. We've identified the area, my lords, and the government is with us on the issue. We'll file a short report, my lords, and bring it on record.
Yes, please.
Paragraph 1 of the order, 37/2025. It transpired that the large-scale deforestation was for the Shillong Peak Ropeway Cable Car project. Full stop. Deforestation had been authorized by the central government. We appointed the learned advocate general and Mr. Paul, learned senior advocate, to visit the area and file a report as to the afforestation which could be carried out around the ropeway cable car project area. Paragraph. The learned special officers have already made a visit. Full stop. It is heartening to hear from them that afforestation in the area around the project is possible. Full stop. They seek some time to make further inquiry. Further inspection and inquiry, and file a comprehensive report with regard to the prospect of afforestation in the vicinity. Paragraph. We adjourn this PIL till 2nd September. The learned special officers shall file a report in the meantime.
I'll be
Wait.
Number 4.
My lords, I am appearing in person. This is the case of the plastic bans, my lord. Plastic, my lord. Yes, ma'am. I must admit, my lord, there's a change in the my lord,
This will take some time.
Yes, my
So
lord.
we will take it up next week.
Yes, my lord.
Your
Yes,
Lordship, in this connection, we have submitted a report, a compliance report as far as East Jaintia Hills district is concerned, because on the last date, they had not submitted their report. So we have submitted that report. And we've also submitted a supplementary action taken report by the East Khasi Hills district. Because this is an ongoing process, Your Lordship. So the different districts are doing it stage by stage, Your Lordship.
Mrs. Yangi, Learned Advocate General, files a compliance report of the state for East Jaintia Hills district and also one supplementary action taken report for East Khasi Hills district. Such reports are taken on record. You're the amicus curiae.
my lord, I filed this PIL.
Let copies of the report be served on the petitioner,
I've received. I've received.
It's already furnished. to
if
them.
not already served.
My lord. My lord.
List this public interest litigation. On 26th August
My lord. Obliged.
Oblige, Your Lordship.
for further consideration.
Let's, by the order dated 22/7/2025, the state and the union were directed to file affidavits, Malads, pointing out to what extent this honorable court retains jurisdiction in view of Malads, a point that was raised by Mr. Khan, that another similar matter had been filed by one Mr. Ashwini Kumar Upadhyay before the Honorable Supreme Court. No affidavits have been received by us till now, Malads.
Your Lordship, in this matter, I got the instruction. It is required some time to file the affidavit. And this is the instruction to me, Your Lordship.
You're for the central government.
I am the central government, Your Lordship. May I just put this material? Just instruction to me, Your Lordship.
Yes.
That's exactly our argument.
Appears to be different, Malads, from what
They want 3 months' time to.
your lordships have seen the paragraphs, Malads, at para 4 and 5. There, Malads, the challenges with regard to section 2F of the NCME Act. Here, Malads, we are only saying with regard to, Malads, the report that has been submitted by the Linguistic Minority Commissioner, what is the status, Malads? That's the issue.
All right, the written instructions dated 1st August 2025 of the Ministry of Minority Affairs to its learned counsel in this court. Now to the learned Deputy Solicitor General.
There is copy to me, Your Lordship.
With a copy to Mr. Devnath, Central Government Counsel, is taken on record. the central government is granted. Four weeks time. To take a decision in the matter. List this application on 17 September.
Yes, I'll oblige.
Number 6.
My lord, this is Aadhaar PIL, my lord. In the Aadhaar PIL, my lord, the issue which has been raised or prayer which has been made in the Aadhaar PIL, my lord, is that the authorities should not insist on enrollment on Aadhaar, my lord. So my submission, my lord, is that under your lordship has taken note of section 7, and your lordship has also permitted the state to seek a compulsory Aadhaar card, but not to deny the benefit to the beneficiaries, your lordship.
Mr. Advocate General, we will take it up next week. This PIL will take some time.
Yes, my lord, it will take some.
Now, I only have a small submission, my lord. My lord, the Aadhaar authority, that is UIADI, my lord, is not a party. So my instruction is that UID can be made a party, my lord. We can file a composite affidavit.
Yes. On the submission of the learned Deputy Solicitor General, you give that name.
UIADI.
I'll give it.
He is made a party respondent. Advocate on record for the petitioner will effect change in the cause title of the petition, amendment of the cause title of the petition. By 18th and serve a copy of the petition on the added respondent by 19th. List this application on 2/8 August 2025.
Man. Must be responsible.
Number 7.
No. You call the T matter. The other matters are transferred to tomorrow, the next day's list.
Item number 10 to 12.
I shall be as brief as possible, but it's almost 1:45, so I don't know whether, unless your lordship sits a little longer, maybe your lordship will have to give me 5 minutes or 10 minutes on the next day. My lord, may I summarize very shortly the queries of your lordship? And
No, you go your own way, Mr. Barry. You don't have to
I need
answer
to
queries.
a little time, my lord, because of your lordship's queries.
No, it is all right.
So, may I start with this chart, which I gave to your lordship last time? This flow chart. There are two flow charts. One is actual demand, anticipated demand. These two colored charts, my lord. Lordships have got them. Where are the charts?
Yes.
So, I tell you, Lordship, why there are two charts. One is actual demand is when there's a new commodity which has come into the market, and anticipated when it's already continuing, so the demand is judged by the last month's sales. So, for sake of simplicity, I'll just take the actual demand flow chart. So, if I just go through the steps, I tell you why, Lordship, this is important. One of the queries, one of the arguments come from the other side, and also queries from this court, is that I think it turns around the supply question as to whether or not it is possible for the CBW to say no to the demand of the supplier or the bonded warehouse. It's a very crucial central question. Part of the argument of Mr. Shah has been that, look here, You CBW are controlling the supply. You are getting it from the supplier and you are giving it to the bonded warehouse. Now what if the bonded warehouse wants a particular product from the CBW, but the CBW, because it wants to promote favoritism or whatever, does not give the product? The supplier is suffering because his brand is not being catered to, the bonded warehouse is suffering. So to answer that question as a point of procedure, on fact I'll come to later, but as procedure, your Lordship will see the steps. In our system which is there in Meghalaya today, whatever may be the situation in Uttarakhand or Chhattisgarh, that is a different situation where one party, which was the board, is controlling both sides. Orders from the supplier and the retailer. But here there is no such thing. Here is only a warehouse, completely different, and he has got no choice but to act on the indent of the bonded warehouse. Kindly see the steps very quickly, my lord. Step 1. Suppliers register brands with the excise department, submitting the Form A, label and pricing detail.
Yes.
Step 1 in purple. Step 2. Excise department approves the brand's MRP and price. This is important. So the brand is approved, the price is approved. The price is just below that of the neighboring state. Step 2. Step 3.
Yes.
Step 3. Consumer demands the good from the retailer. Actual demand chart, my lord. Your Lordship doesn't have it, my lord. I'll resume. There are two.
I had two of actual demands.
Oh, I see. I see. So your Lordship will kindly adjust, my lord. If I start again on the actual demand, my lord, Justice Jingo may not have had the actual demand chart. So, step 1, suppliers register the brands with the department. Step 2, excise department approves the brand and the price. So, brand and price, both are fixed. 3, consumer demands the goods from the retailer. Step 3 is very, very important, my lord. Consumer demands the goods from the retailer. So, what does the consumer demand? A particular brand, very important. Consumer wants 5,000 cases of Old Monk. That's what the consumer wants. Step 4. Retailers apply for retail permit, pays lifting fee and VAT. Now this retail permit, there are several permits here. This retail permit will give that brand. This permit has to come from the government. That brand will be indicated in that permit. Old Monk, in that permit. Then, step 5. Excise authority issues the retail permit. Step 6. Retailer demands the goods from the bonded warehouse. Lordship says, step 7. Bonded warehouse now applies to import permit. The second permit. Bonded warehouse has to get an import permit. Bonded warehouse import permit will also have Old Monk rum specified in it. The brand will be in that import permit. 7. 8. Excise department issues the import permit to the bonded warehouse. 9. 8 to 9 is very important. BW makes the indent upon the CBW. Lordship has seen that?
Yes.
Step 10. CBW applies for import permit and pays the ad valorem, that is the excise duty. So, kindly, carefully analyze the steps 8, 9 and 10. That import permit, there are 3 import permits. Each import permit will have the brand only what the retailer wants. Quantity also, I've told. Yes. Brand and quantity is indicated in the import permit 1, indicated in the import permit 2, indicated in the import permit 3. It is not possible in our system, my lord, for the central bonded warehouse to turn around and say that, sorry, I can't give you this. Because the import permits already mention the brand. He is bound to, and the import permit, the CBW has to get, again, the third one also has to have the same brand. It has to match the earlier import permits. There can't be any deviation in the system. My lord, have I?
Yes.
Yes. In this system with the import permits, there can't be deviation. In Chhattisgarh and in Uttarakhand, there can be deviation because this procedure is not there. They will just supply what they want and demand will come and they have full control of demand supply. Here, indent is specified against permit. The retailer raises an indent. The bonded warehouse takes that permit. The bonded warehouse raises an indent on CBW. Another permit with the same brand and quantity. CBW takes a third permit from the government with the same brand. Step 10. Then step 11, another import pass to CBW. Step 11, third column, also has the same brand. Step 12, CBW makes an indent from suppliers. Same thing now, coming down the chain, CBW asks the suppliers to supply. Step 13, supplier supplies the goods. 14, goods received from the supplier stored in CBW. 15, goods are dispatched to BW. Then 16, dispatched to retailer. 17, retailer checks the store and consumer gets the demanded goods. In this cycle, in this pattern, there is no scope. At steps 8, 9, 10 and 11, there are permit after permit after permit. You cannot deviate from the brand and the quantity. You cannot say at the stage CBW comes to the CBW, CBW turns to the bonded warehouse and says, sorry, your permit may say Old Monk, but I would rather, I don't have Old Monk, I'm going to give you McDowell. Because one of my partners is promoting McDowell. It can't be done. It's not possible under the system. I'm showing your lordship the procedure. There is no scope. That's the point. So, if the retailer wants Old Monk, the bonded warehouse will have to apply for Old Monk. The CBW will have to supply the Old Monk. Now, what is the safeguard? CBW brand of Old Monk is already registered with the excise department. So, the CBW has to keep 1 month stock of Old Monk under the rules. So, he has to supply from there. Now, all this story of supposing somebody wants to be favored and CBW will say, I don't have this and I don't have that. This procedure does not countenance that at all. Because the indent process and the import permit process does not permit a deviation from the chain. Have I made myself clear, my lord? This is the chart. That's why I wanted to show this chart. So, just to, again, I mean, at the risk of repetition, your lordship had said that today the bonded warehouse has lost. It's like a market, he could have selected Hilsa or Betki or chicken or mutton. Actually, the bonded warehouse from this chart has no say at all. Zero say. Because he has to indent in terms of what the retailer wants, what the customer wants. Customer wants Old Monk. Retailer tells the bonded warehouse, you have to buy Old Monk. Retailer has not got any choice of selecting any other brand. He never had the choice in the earlier situation. He does not have the choice now. No difference. Only difference, he has to get it from CBW now. He could get it from the supplier earlier. This is the only difference. Some difference in negotiating power of the credit facility may be there. I don't dispute that. Minor difference. He could have maybe he says he could have negotiated a better credit with that supplier directly. Now he cannot negotiate with the CBW because of weightage or whatever. That's a commercial matter. I'm not getting into it. But choice of brand is not there. My lord, the Chief Justice query was that his choice has been taken away. He can't buy Hilsa or Betki now. He has to go to the market and buy only Hilsa which is available. No. Hilsa is what? He's only an agent. He's not the buyer. He's an agent for the retail shop. So whatever his boss tells him, he has to buy. If his boss says Hilsa, he will buy Hilsa now from CBW. Earlier he would have bought Hilsa from the supplier. So his choice doesn't exist. Choice is that of the customer. Customer is the king. Customer makes the choice. Retailer is the king, he makes the choice. The bonded warehouse, the CBW and the supplier merely comply with the choice. My lord, this is the factual situation, the market. Now, my lord, next question is, yes, those two judgments of my lord Mr. Shah cited. One is the judgment, those are very important because they actually support me. One is the Pano Ricard judgment and the other is the United Spirits judgment. If your lordship kindly takes these two judgments. Have you? Judgment is already there. Your lordship has these two judgments before your lordship. Copy. High Court of Chhattisgarh is one judgment and the other one is, which High Court is this? Uttaranchal. Uttarakhand. But if your lordship has whichever judgment, may I start with the Chhattisgarh judgment? Lordship has it?
Yes.
Now, here the relevant authority, which was the board, this is the board case, right? What had happened was the court found in this case, very important, that because of the activities of the board, the supply which was being taken from one set of suppliers, the petitioner, had drastically dropped, and the other party was being favored, and their revenue and sales has drastically increased. This was what was found. As a question of fact, kindly comes to paragraph 36. Kindly says, paragraph 36. How the brands of the petitioner, Imperial Blue, Royal Stag, Blender's Pride, has a massive decrease compared to the previous years. Paragraph 36, very important, my lord, because this is a situation where the petitioner showed that my figures have dropped this much, his figures, my rival's figures have gone up that much. This was shown as a question of fact. Paragraph 36. They had the supply, but the indent for taking the stock was not being given. Paragraph 36. Kindly see. Lordships have paragraph 36.
Yes.
Figures. This is the brands. Imperial Blue for 415. So the 70% decrease. Royal Stag, Blender's Pride. 15 to 16 to 17. Huge decreases. Next page also huge decreases. Now, so far the rivals are concerned, kindly come to last bit of paragraph 37. White and blue premium whiskey and all that. Kindly come over the page. Their figures have increased by huge. Two jibs rejoined. 13, 5, 11, 52, 50,000. 15,000, 10,000, 32,000, 8,500, 25,000. So, this High Court found a situation, Chhattisgarh, where the demand, the discrimination was written right on top. His supply was less, other supply was more being taken. In that situation, the High Court acted and directed that you will fix the minimum stock, and the orders which were placed for the months corresponding to the sales shall be supplied. That page, paragraph 56. Fourth respondent directed to take the monthly average retail sales and place the difference in backlog and supply orders from July 2013. So kindly see what the High Court did. I am satisfied, said the High Court, that you have been discriminated against. The figures show your revenue has gone down, rivals' revenue has gone up, your supply is not being taken, in your place the indents, so I am directing all the backlog indents should be given to you and publish the minimum stock. This is when the High Court intervenes. My lord, in this case, where is that figure before your lordship? The essential thing before your lordship gets into this question is that first the High...
As I said, that it is in the working of the scheme.
Correct,
that
correct.
One will know whether it is arbitrary or...
Right, so in the working of the scheme, I have shown your lordship there is no scope for any...
Now suppose there is a request from a body of retailers that you get so many bottles of this brand.
Yes.
Now that indent is placed, it goes to the
bonded warehouse.
It goes to the bonded warehouse, and they also place an order to the importer, import it, but don't supply it. You keep it in stock to sell it in a...
And you can't do that. I just showed your lordship the chart. The CBW has got to supply it. He has to make the indent upon the supplier.
To supply on a complaint.
Of course.
On a complaint.
Of course.
But
your lordship is absolutely right. It can happen.
Working.
But where is the complaint? There's no complaint.
The action of the notification has not started as yet. It has not been implemented as yet. Is not been...
Notification has been implemented from 2020, my lord. 2020 onwards has been implemented. 4 years the central bonded warehouse is running perfectly well.
It's not stayed.
The working, no, there's no stay. 4 years they're running perfectly well.
I see.
They're making tons of money, the suppliers. I'll show your lordship. The petitioner's revenue has gone up by leaps and bounds. The excise revenue has gone up by leaps and bounds. Nothing has happened at all adverse. It is only speculation. Like here, lordship has seen all these figures in this judgment. May I ask myself, where are those figures here? Where is the loss of revenue? Nothing. Only somebody may discriminate. I tell you, lordship, there is one bottler, one supplier, where there is one common partner. Minuscule 2% or 3% of the market, maybe. That is a theoretical possibility. That has not happened. There is no complaint. And loss of revenue has to be shown, my lord. Paragraph 36. Here, loss of revenue was shown in chapter and verse. All the figures are here. So, the least that could have been contended, if you are talking about shortage of supply, favoritism, the first thing before the court is you have to show these figures which were shown before the Chhattisgarh High Court. That look here, my rival's supply has shot up, my supply has gone down. That's what was shown in this judgment. Significantly absent in this case, nothing is shown. And nothing is shown for a very good reason, because they have not suffered any loss at all. Nobody has done any shortage of supply. There is no favoritism. Otherwise, they would have given the figures to your lordship like it has been done here. The fact that no figures have been given to my lords shows that there is no loss of revenue of the nature as was in the Chhattisgarh judgment. When that figure comes to before my lords, and if your lordships are ever satisfied that that has happened, there is always scope for the court to act. 6 months from now, if a fresh writ can be filed saying this is now the discrimination, and that's not the policy being struck down, that is the implementation of the policy being questioned. That can always happen. Any policy, my lord. Tomorrow there's a corporation sanction in Shillong. Some corporation officer sanctions a building which should not be sanctioned. My lord, they can come to the court. That doesn't mean your lordship will hold the Corporation Act as ultra vires because it can be abused somewhere and therefore strike down the statute. No. Your lordship intervenes to remedy the mischief. Now the mischief here is favoritism and lack of supply, for which the figures have to be given like Chhattisgarh. No figures have been given. When no figures are given, it's only speculation. And according to me, under the chart which I've given, in our case, almost impossible. Because when the indent comes to CBW with the import permits in the name of one brand, it is not possible for CBW to say, oh, I will give you this. Then all the import permits have to go back again. All have to be reapplied for from the retailer downwards. So it can't happen in the system. And it has not happened. To our knowledge, it has not happened and there's no complaint. So kindly, this supply side theory, my lord, is only speculation. This was not speculation, this case. This was reality, and the court interfered. My lord, the other judgment also, lordship sees, paragraph 17. The name of the judgment is United Spirits versus Uttarakhand Agricultural Produce. The other one. Straight over paragraph 17 if your lordship comes. Paragraph 15 and 17. Kindly see paragraph 15. The fact remains that sales of the petitioners had drastically dropped despite there being no consumption or supply related orders. Retailers are facing grave hardship. They are not in a position to cater to consumer demands, etc., etc. Then paragraph 17. It is not every fancied possibility of discrimination, but the real risk of discrimination the court must take into account. My lord, this is to be emphasized. As per Annexure 7, 3 lakh cases were sold by the petitioner company period August 14 to October 14. 4 lakh cases were sold by the petitioner during May 15 to July 15. Then suddenly there has been a drastic fall in the orders placed for the petitioner by the Uttarakhand Agricultural Board. The sale fell to 10,000 cases. So from 4 lakh cases, the sale fell to 10,000 cases. The case of the petitioner is the brands are available, no orders are being placed upon them. Kindly see the facts. Where is that case here? The brands are available, no orders have been placed. Every order through the bonded warehouse is going to CBW. Every order is being honored according to us. And whereas from 4 lakh cases, it went down to 10,000. So we would like to see we would have liked to have seen from the petitioner's side, this huge drop in revenue and the huge drop in sale. These are all, and what was the remedy the court gave? Not that the thing was struck down, policy was struck down, only remedy was fix the minimum stocks and publish it. My lord, we have no difficulty if your lordship directs the CBW to publish the monthly stocks in the interest of transparency of every brand. That could be a guideline your lordship may give in accordance with this judgment. One more I may suggest, my lord, since your lordship is thinking of tweaking in case of possible future problem. Today there is no problem. I apprehend there will be no problem tomorrow either. But if there is a future problem, your lordship may consider a direction that the state, on receiving any complaint of short supply or favoritism, is directed to take cognizance of that complaint, bound to take cognizance of that complaint, make an investigation and act accordingly to remedy the problem which may have arisen in this regard. Certainly that would be a legitimate further direction from the court to make sure that from the supply side or the indent side, no difficulty is caused to the supplier. That direction can definitely be given. Your lordship may give a direction that monthly stock should be published of each brand, so that, my lord, the suppliers know that their brand is in stock. These are directions which can be given. But beyond that, my lord, with greatest of respect, if the CBW is to be maintained at all, then the question of any other tweaking doesn't arise. Otherwise, the whole concept of CBW will disappear. My lord, may I now, I have taken some instructions on this. The CBW, before the CBW came into being, what was the problem? In the remote areas, so further from Shillong. Shillong has basically a huge percentage of the market. But there are remote areas like Tura and other, more remote from here, where, my lord, the supplies are much less. They're smaller remote areas. Your lordship was concerned about how consumer demand will be impacted. Let me tell your lordship, today, even in the smallest, in the remotest parts of the state, if a customer wants a shop to stock, say, one crate of Old Monk, then there is no difficulty in that shop stocking it. Any brand. Earlier, it will not stock it because the cost of transporting that Old Monk to that remote area is not worth it for the supplier, because the problem is that you need one full truckload to supply. So the brand availability will depend upon, if it's a big shop with a full truckload, he will get it. If it's not a big shop without a full truckload, then he will have to suffer. That brand will not be available to people of that remote area. Today, all brands, however remote, they will put an indent on the bonded warehouse. Bonded warehouse from the CBW will get it. So all the brands are fully, all the places are fully stocked. The demand is much better today. I am told that, my lord, in Shillong, where the more expensive brands used to be only a few, after this CBW, now practically every brand which is available in the biggest cities of India is available here. Because now there is a central stocking which has, from expensive to cheap, all the brands. What was happening earlier was the cheaper brands, they were not reaching for this reason, they used to drink country liquor or whatever. Now, my lord, with the availability of the brand, kindly see, availability of the brand has gone up. Therefore, the consumption and availability, the demand has risen. Tomorrow, if your lordship strikes down this policy and the CBW goes, then again back to the old system where the brands will not be made available. My lord, I'll take another 20 minutes, half an hour the next day and come. I promise your lordship, my lord. I'll answer.
And then who will...
I think then maybe, I don't know, the AG or the...
Altogether, there are three writ petitions, my lord. One by the supplier, my lord,
Yes.
which Mr. Banerjee is leading in this matter. Second is by the bonded warehouse, challenging the policy, my lord.
Yes.
The existing bonded warehouse, there are about 40. And third is, my lord, third writ petition is pertaining to the policy of the government to come out with the second central bonded warehouse,
Yes. Where we had passed an interim order.
in which your lordship has passed the interim. So far as second matter is concerned, my lord, the bonded warehouse, I need another 15 or 20 minutes. Mr. Banerjee has covered all the aspects. Almost only...
Yes, as far as the first two are concerned,
Miller.
the issues are absolutely common.
Yes, ma'am.
Cost title may be different.
Yes, ma'am.
But then,
The issues are common.
yes, we expect, and certainly so,
Yes,
that there will be no duplication of arguments.
Yes, yes, ma'am.
So you will make submission.
So, and now the affected party is central bonded warehouse.
I'll also make some such.
On affected party is central bonded.
And I am also there, my lord, in the second matter, my lord, with the bonded warehouse. Because with some issues are, my lord, slightly on the legal principle issues are somewhat similar, but the narratives are
No,
slightly
it is all right. You are for the central bonded warehouse
Yes, ma'am.
and opposing the application.
Yes, ma'am.
And what about the application for proliferation of central warehouses or the setting up of the second one?
our writ petition which my lords are
If I may interrupt my learned friend, he is not opposed. He is on the same side as the state so far the policy is concerned. But he is on the opposite side of the state when it comes to making the second bonded.
Central bonded.
That's
So that my lords had directed that the third writ petition to be taken up after this writ petition is heard.
Whatever.
My lord's order is there now, so we'll argue it after this matter is over. Because if my lords are to strike it down, supposing I'm assuming it against myself, then the question of the third writ petition surviving does not stay there, my lord. So we need not even argue that.
Because the issues are common, my lord. All matters common. Because if my policy is fine with central bonded warehouse, I have a power to establish one bonded warehouse. Then I have power to establish more than one.
Yes.
And therefore,
On that count we disagree, my lord.
just my friend said.
And singular, my lord.
That will come later.
That will come later.
Now, my lord, I have already gone with the tender. We have got the bid also. We have got the money also. Everything. Now they want to make it infructuous by delaying it. And the issue is common, my lord. And your lordship has indicated so far as my policy is
today India and
concerned.
China opposing the United States. Later on we will have to fight out
With the
China.
greatest of respect,
Both are now opposing.
with the greatest respect, Malad, the amendment was confined to only one bonded warehouse. Malad, that is where Malad became with the question of monopolistic Malad entity being created.
And my lord, the
The very fact
advantage.
that the state wants to establish a second bonded warehouse itself, Malad, ultimately, Malad would warrant striking
So the
down
whole
the
argument
provision of
goes.
the amendment.
The whole argument of monopoly goes, my lord, if the second, supposing I am to lose in that third writ petition, their argument was monopolistic
My lord, now
notification
Malad,
also.
the challenge is
Bonded
to an
where will have-
amendment.
bonded
The
warehouse
amendment is
will have
confined
choice.
to one entity.
Bonded warehouse will have the choice either from to take the liquor from A bonded warehouse or B central bonded warehouse. So that kind of now earlier the apprehension was that central
Malad,
bonded
Malad,
warehouse
that's not a
will
question of
influence
apprehension.
the
I must
market.
stop my learned friend.
That was the
Well, the
reason my lord, the
amendment is
technical committee was
ultimately, Malad,
constituted.
The amendment provides for establishing one central bonded warehouse.
One single bonded warehouse.
Now, Malad, my learned friends want to establish a second central bonded warehouse, which itself strikes at the
My
root
lord,
of the
I will
amendment.
show we have got 40 bonded warehouse and one central
It's not
bonded.
that, Malad. We are now talking about a challenge to an amendment, and Malad, we must confine ourselves to the challenge to the
Very well, my
proposed
lord. I'll
amendment.
answer this question. I'm grateful Mr. Shah has raised the question. I'll answer this. According to Mr. Shah, this is a concession of our entire case and concession of monopoly. With respect, totally incorrect, my lord. It's not a question of monopoly. I can have a duopoly. I can have an oligopoly. Question is whether if the demand is tomorrow, if the demand goes up by 10 times, my lord, can it be contended that only one
Well,
bonded
let me-
warehouse? It's a matter of
well,
policy.
let me-
If
let me
a demand
conclude.
requires more, then another one will have to be created.
Well, it's a question of time now. Let my learned friends conclude, Malad. Sometimes they must
Yes,
conclude.
yes. Of course, of course. I will.
Yes, Mr. Banerjee, when would it be? In the
I
near
can do it
future?
on Monday itself, as early as your lordship feels, or Tuesday, Monday or Tuesday, whichever is convenient.
You'll be able to conclude on Monday.
Yes, yes. But your lordship gives me like not 10 minutes, well, at least half an hour, 45 minutes. I'll conclude.
No, you have got for about 45 minutes today
Yeah,
also.
I'll conclude. I'll only address your lordship on this margin question, which your lordship's query.
My lords may keep it consecutively from Monday, Tuesday, Wednesday, because we will also conclude, my lord. Try to conclude.
Malad,
Yes, Mr. Saha is
then-
my lord.
there is a time
Rebuttal
constraint.
will
Now,
come,
so
Malad.
if your lordship's time permits, Malad, consecutive days, Malad, we can
I have no difficulty, my lord. I mean,
take one session in response to all of it. Malad, maybe for 30 to 45 minutes, I shall finish my response to all of them.
All right, 25th to 29th consecutively, whole week. 25th to 29th?
25th to 29th.
Yes.
Great.
Monday to Friday?
Grateful.
Lordship doesn't want to keep it next week, my lord.
No, next week, after Tuesday, I may not be available for 2-3 days.
Because 20th, 20, but I'll finish by 25th, 26th anyway. So 25th, 29th.
Grateful.
Grateful.
Puts us in difficulty.
You see, the cherry is one.
Yes.
It doesn't grow, it doesn't contract.
It's the bites. How many
There
bites?
were-
Who gets how much bite?
4 bites, now there are, say, maybe 16 bites.
Yeah.
Now, why should the 4
That
allow
is,
that?
yes. We'll see.
Thailand cherries are a little bigger, my lord, unlike Indian cherries. So
Without
we can
any
have
change,
bigger bites.
without any
That's the only thing. Only thing I have to address, my lord.
in the description of quality of the cherry.
That is what Mr. Shah started with, my lord. That is what
Why
we are
should they be
ending
allowed?
with.
And that too not by the free market play, by government imposition.
Government is getting no cut of this commission, my
No,
lord.
no,
Sorry.
this
Zero. We are not getting any. Your lordship can fix any commission for Mr.
No.
Shah for any other. We are not concerned, my lord. It is only the private players who
There would
are.
not have been any central bonded bearers question unless this amended notification would have
That's
come.
right. That's absolutely. That is correct. But we have given the reasons why.
That is where the shoe pinches.
Yes,
it
that's right.
doesn't.
Of course.
It,
But
it hasn't
my
come
lord,
out of
at the end of the day, if a policy is valid, a revenue policy is valid, shoe pinching to the extent of 1 or 2% does not allow it to be struck down. At the end of the day, 250%, 4 times.
More than 25%.
My lord, this is not a widow or an orphan who's been deprived or thrown out on the street. This is a party whose sale has gone up 3 to 4 times in show.
That
There is
is
no
why-
problem.
that
Revenue
is-
has gone up.
that
And
is-
revenue has gone up.
We are talking 100 crores, my lord.
That's why the
How does
writ is-
that have anything to do with the policy amendment? Revenue
That
has
is
gone
why
up
the-
because the
No,
no.
demand has gone up.
Policy, if it has nothing to do with the policy amendment, I'm grateful to my lord friend. Then how much margin is being charged is irrelevant to the policy.
No, my lord, it's not that at all.
Experience counsel who are-
You can't, either the policy, the margin is so unreasonable that it vitiates the policy, or it is not.
That is why, by the most experienced counsel appearing in the matter, this writ has been allowed to be pending for 5 years. Otherwise,
That, my lord,
would
is-
not,
I can't.
any one of the
Mr. Shah has been there.
former chief
He
justices
can answer that, my lord. I have no idea.
presiding over the bench being compelled to conclude the matter.
No, we are grateful, my lord, that at least
because
judiciary is.
no, because
Now, Mr. Shah's smile I've seen for the first time today.
because the writ petitioner does not up to this stage need an interim order. That is why it is.
Yes.
They have allowed it to be pending.
His revenue is 250%. I'll show you, lordship, my lord.
All right. Mr. Manager does not conclude. List this batch of these writ petitions on a day-to-day basis from 25th. To 29th August. At a time to be indicated in the cause list. All right.
Much obliged.
Grateful, very grateful.
Let's item number 9, my lords. We had mentioned the matter yesterday. My lords had indicated, my lords, if I mentioned
This item will take time, my lord. It requires detailed
let it remain on board, my lords.
It will remain on board.
Let it remain on board for the time.